So we are in time. Hello, everybody. My name is Thomas Hoeren. I have to talk again about law in the digital economy. We fixed our first big part of the winter term. That was intellectual property rights in data. Just to remind you, the general principle is law information has to be free. Exception from that rule is software protection, database protection, and the fascinating and confusing word of acquis communautaire. That means everything and nothing in the European IP law. We have started to talk now about unfair trade law. And I have told you a little bit in a bird's eye view on the various regulations we have in Europe. There are strange regulations and directives on PCB advertisement. That means platform to business advertisement. We have a directive, a new one on political advertising. We have special rules on advertising for green products. That means products which are praising certain health effects, and sometimes that's misleading. We have finished even that part, and now we come into a dangerous part, because we will see in a minute, we have a lot of national regulations, because Europe has not harmonized all the aspects of unfair trade law. The national states have to decide what they want to prohibit and what not. You have already got 3 different packages from me. One package yesterday on the general principles of unfair trade law in information law. Then you have a second slide, which you already got 2 weeks ago, on the special rules of the European legislator, including AI and unfair competition law. That's what we not have talked about yet. And then I send you a third part of slides, because I notice that unfair trade law is a very strange mixture of 2 topics. There's advertising regulation and unfair competition law, because in Europe we mix up these both parts. Therefore, we have a third package on unfair competition law and information. So we start now by the first part of slides, unless you have questions. Is there anything which I need to answer now? The exam will be prepared. We'll send you, to mention that, our test in a test version in January, only for you to test what we have discussed on a multiple choice questionnaire. So the final exam will be multiple choice, but you have to be really aware of what you're doing. It's not only saying yes, no, yes, no. You have to answer the question very close and very fine. So that is all from me. You are all fine, and then we can start. And I need to open my slides, which will be done in a second. So, you have a question, Mariam?
Yes, I think yes, and another person as well. At first, let me.
Oh, The microphone.
Okay. Am I audible now?
Yeah, it's audible.
Well, at first, I would like to thank everybody, say hello to everybody, and once again, I would like to express my gratitude for being here all. My question is in regard to the legal essay, which is indicated in the overview description of this course, which we have received in the beginning of our lectures, our course. Well, it was indicated next to the summer course, and I wondered uh, if I should prepare this essay during the summer semester, and then hand it to you, or it is provided for the students which will have the same course in the summer semester.
So we haven't discussed about the essays now because it's a question for the summer term. Maybe it will be like that. You are listening to all which is said in the summer term, and you are deciding yourself on the topic which you want to write. So that makes life quite easy, but we are not sure. We wait until January. We will inform you in January at the beginning of the first lecture in January how we think about the essays. For the winter term, you only need to write this multiple choice test, which is necessary for us to know, have you understood all which was said? So wait until the beginning of January, then we inform you about the structure of the essays.
Okay.
Okay?
Yes. Thank you very much. And I have a short second question too. Should we cover and explore the topics, the cases, the legal points emphasized on the slides and during our lectures to successfully complete the exam, or are there any materials predetermined in order to enable us to complete the exam?
If you're asking for the multiple choice test,
Yes.
you can use whatever you want to use. So it's an open book test. It only consists of questions or problems we have discussed during the lecture. So you don't need to check all your commentaries and books at home. If you carefully listen to what I have said, you are capable of answering the questions perfectly.
Okay. Thank you very much.
I'm welcome. So now I start as I call it UWG International to give you a survey on the structure of unfair trade law. And as I said, this proves to be nearly impossible due to the fact that we have so many different countries in Europe. And if you take even parts of outer Europe, you see a whole bundle of different strategies towards unfair trade law. I only explained on that slide the situation in France, UK, and Germany. It would be nice, of course, to hear from you what is the situation in your country, perhaps Uzbekistan, and especially Georgia. So let us take Germany, UK, and France. So in France, we have no unfair trade act, what we have in Germany. So in France, I say, unfair trade is a problem on the one hand in B2B relationships. That is a problem of tort law. So they call it concurrence déloyale. That means if a competitor is behaving in an unfair way, that's solved under tort law. Then we have a section separate on the problem, how does a company behave in relation to consumers? That is, of course, consumer law. So they have a total division. In Germany, of course, we are the best nation in the world, nation number one. We have a very nice, we call it UWG, and a special act on unfair trade law. You will see in a minute that this Unfair Trade Act has two provisions which are very important. One on unfair trade in general. So it's a general rule saying that every unfair trade between competitors is forbidden. And we have separately a general prohibition of misleading terms. Germany has, apart from that, a third element which is always a catastrophe, because there's a provision in 3A of this act saying that any other statute in the world can be read as a violation of unfair trade law. So it can take other acts in Germany and interpret them as unfair trade law. So take, for instance, data protection. The European Court of Justice just decided that a violation of of data protection law might even be unfair trade within Section 3A of this act. In Great Britain, which was a long history of friendship and enemy relationship with Europe, they say we don't have any act at all. We don't have, like the French people, tort law and consumer protection law. We don't want any influence on trade. Trade is so important that we should not interfere with the things which are done between business and business. So they only have a thing called self-regulation. So they have a code of conduct for advertisement, code of conduct for advertising to minors, a code of code for advertising in the health business. It's a very nice feeling in Great Britain that every company is protected in their special relationship towards doing marketing. We have one element which might solve this very fragmentary approach. That is the DSA. We talk about the DSA in summer term. The DSA is a Digital Services Act. There's a new act, a regulation. It's called Act, but it's as a matter of fact, it's a regulation on the liability of digital services, especially YouTube and others. And this DSA, which is already entered into force, had an Article 25 on dark patterns. Dark patterns is a very unclear term what it is. You see it in subsection 1. Providers of unknown platforms should not design, organize, or operate their online interfaces in such a way that users are deceived, manipulated, or otherwise significantly impaired or hindered in their ability to make free and informed decisions. So dark pattern means any way of misusing the internet or AI to create an atmosphere where users might be manipulated, and manipulated, there's an interesting test, free and informed decision. So the user should be informed before they're doing decisions, and the decision itself should be free. I will come to that Article 25, and I've described some examples of AI. In the AI world, there's a typical situation where dark patterns are very often be found. And we have a second provision in the DSA, very smallly printed, Article 26, that says online platform providers shall ensure that users are able to recognize for each individual in the following. So there should be a clear information duty to online platform providers. Though the new user should know that the information is advertisement, that the person in whose name the advertisement is displayed, that you know who has made this advertisement, then who has paid for the advertisement. So even further, meaningful information on the main parameters for determining the user to whom the advertisement is displayed. So it's a rather broad information duty, but only for platform providers. So what is a platform provider? That's the topic we discussed in summer. So apart from that, we have this, in Germany is the famous UWG, the famous Act Against Unfair Trade. It's a very old act from 1909. It's meant to have a protection of consumers. Again, you have consumer protection mixing up with unfair trade law, a protection of other competitors, and the general public. So very broad concept. When you have seen the situation in Germany, most protection is offered very quickly by injunctive release. You go to court and you get some very often between 24 hours an injunctive decision. Before you go to court and say this is unfair, you have to send a warning letter and say, please cease and desist. And if you're not doing that, you have to pay a contractual penalty. So these warning letters are a terrible business. If you're running your own company, you get a letter saying, I'm a competitor, I warn you, you are making a terrible mistake. Please to stop that and sign a contract saying I am obliged to pay a penalty if I make a second infringement. So this letter can be sent by competitors. We have special warning organizations. So special companies only responsible to send you a warning letter if you have made a mistake. So as I said, this is not known in France, and this is not known in Great Britain. To a certain degree, that is existing as well in Austria, but they don't know this element of warning letters. They don't have these warning letters. So every consideration of unfair trade law starts with the question of conflict of laws. When do we apply which competition law? And the principle is, of course, decided by each national courts differently. So if you go into a French court, they would, of course, say, if you want to say this competitor is infringed, the rules of concurrence déloyale, they will apply principles of tort law to define the relevant law. If you are saying in France, this is an infringement pretended to be in the relationship to consumers, they will apply, of course, the principles of international law of consumer protection. In Germany, we say every decision on the matter of UWG depends on the question of final market intervention. So we are asking, where is a homepage directed to? What is the purpose of a homepage? And then we decide, is a German competitor or a German user, then we apply German law. You see the problem. Here I've mentioned the Court of Appeal of Frankfurt in a famous decision. There was a case which had to do with a travel agency from Egypt. And they make a homepage for German tourists who should come to Hurghada. And the question, of course, is what kind of principle can we apply? Is that final market intervention as usual? This homepage is directed, of course, to German tourists and tourist market. That's the reason why the Court of Appeal of Frankfurt said we will apply German rule or law because this homepage is directed to Germany. Apart from that, there's a different rule if you have to do with European companies, because the European Commission decided in the e-commerce directive and in the DSA that the country of origin applies. So one example was there was a very nice homepage in the internet where you can, which you can use in order to complain about neighbors. It was directed to Germany, but it was made in Finland. So if you know Finnish guys, Finnish have everything in law what we have, but they don't have a personality right. So you can complain about Finnish people to whatever you content you want to. You can say, you damn old fucking son of a bitch as a neighbor, I hate you with the utmost. You can say that in Finland. So a German neighbor complained about that homepage and said, I am embarrassed by this homepage. And the Berlin court said, is that homepage coming from outer parts of Europe? Then we would apply final market principle, where's the homepage directed to? Or is it a homepage of two European parties? Finland is, of course, unfortunately, a member of the European Union. So if a Finnish company makes a homepage directed to German users, we don't apply final market, but the country of origin. That means Finnish advertisement law applies. The Finnish advertisement law doesn't know any personality rights. So you can complain using a Finnish homepage about whatever you want to do without taking care for German law. So I hope you have understood the principles, these two principles, because they are very complicated in their interference. So if you are in national law, we have to distinguish between specific rules, area-specific rules, and the general clauses. That means the general principles of prohibition of unfair competition and misleading behavior. So the European Court of Justice had made a new decision on the question, can we apply market rules or can we apply country of origin rule? That has something which has to do with Cyprus. Perhaps you know these strange people who want to do online gambling. They like to gamble in the internet. That's totally prohibited in Germany, but it was not a problem in Cyprus. So every online gambler use then Cyprus homepages to gamble. So Germany said, stop that. I hate you. We will prohibit your website. So the European Court of Justice said, Cyprus is a member of the European Union. So in general, the marketplace principle decides, but we have a country of origin rule. That means a Cyprus provider cannot be fixed and bound by German online gambling laws. It's prohibited. So let us now start with the special rules. All these special rules are all different throughout Europe, and if we take Uzbekistan or Georgia, you will find specific rules based on a national law, which you can find in no other country. In Germany, for instance, a special topic is protection of minors, of young people. Then we have product-specific rules. Then we have profession-specific rules, and then we have marketing-specific rules. Let us simply go to the protection of minors in Germany. That is, again, a problem of online gambling. The media authority in Germany said, we want to protect minors which are losing their money in Cyprus by online gambling. But again, this is not possible, as the ECJ has said, because Cyprus online gambling also organizations are only bound by Cyprus law. For the protection of minors, we have again the DSA, because we have a specific rule in Article 28 for the protection of minors, because this provision said a provider of online platform should ensure a high level of privacy, security, and protection of minors within the scope of their services. That means they have a high level, whatever a high level is a high level. Nobody knows. It's only said high level. So in various countries, I've just discussed in Georgia last Friday with Anna, and she told me about the problem in Georgia for age verification. So take, for instance, the question of selling alcohol on the internet. We have special restriction for these products regarding adult people, they can, of course, buy alcohol via internet. How can you prove that somebody is over 18 or is a minor? In Germany, as nobody has a clear idea how that works, they simply said, yes, I am above 18. No, I'm not above 18. And that's all. Is that enough? Of course not. That's not a reasonable, efficient age verification. In Germany, we have started to use all our intelligence to think about, for instance, identity card or passport. So I can tell you a story. I'm a fan of films since my 20th birthday. I'm a fan of documentary films. And when I buy documentary films using Amazon, and the documentary film was sent from Great Britain, it has no age verification. So the man from the postal office is standing in front of my door, is looking to me, Professor Hoeren has bought a porno film, and said, I need to see your passport. I tell him every time I'm not buying pornos, I'm buying, for instance, animal films. Ha, 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 that's what he said. So in Germany, it's most done by showing your passport or identity card. You can even try to use it, the cash card, because the cash card can only be received by an adult. So, but this problem has not been solved. So next topic, that was all for protection of minors. Now we are talking about profession-based specific rules. There's, for instance, a problem in Germany, Austria, and to a certain degree in France, because we have special provision, we call them freie Berufe. They are everything what you want, but they are not free. That has to do with doctors in medicine, advocates. They belong to a special group of people called the free professions, because they don't get any money for their work. So, can, for instance, a doctor give a video consultation via internet? Is it allowed to use a consultation service with a doctor? That, for instance, is regulated in Germany by a special act, the so-called Heilmittelwerbegesetz. So we have a special section in an act saying that it's not allowed as a doctor to make video consultation. Then we have the issue of advocate. We have for some areas special regulations called MOBE that are medical professional rules saying that a doctor can consult his customers if it is medically justifiable and the medical care is insured. This regulation has been interpreted by the court of by many courts to say that as doctors don't have a good equipment for really speaking to a customer, is forbidden. For advocates, we have special rules on the sending information and talking to customer via email? Can an advocate send emails to his customers? And these rules forbid the use of unencrypted emails because unencrypted can be read by anybody. This is in general a violation of the confidentiality which we are supposed to be the main obligation of advocates. So we have some advocates listening in YouTube and Zoom. Perhaps you know some advocates who are still sending unencrypted emails to their customers. It's always a very bad thing to do that. So you should be aware that you have to think about a strategy to cope with that. And the last issue is legal tech. Perhaps you know legal tech. Legal tech means you're taking a kind of machine, you can even use AI for that, and you're saying, this is a very standardized question, we'll solve that by asking the machine. For instance, if you want to get compensation from flight companies who always are late with a flight, you can sue against the flight company, but that takes time and a lot of effort to do that. You can ask an agency who has a specific tool, a technical tool, to sue against a flight company. They're collecting the money in a standard procedure and giving it to you. So that was regarded in Germany as a total prohibition of legal professional rules because legal questions can only be dealt by advocates. It cannot be dealt by a machine. Unfortunately, we have solved that issue by a change of our regulations for the work of advocates, and said, if you have such an agency, is allowed to collect the money if certain provisions, if certain requirements are fulfilled. I've written it down here, a collection of third-party receivables. If the collection of receivables is carried out as an independent business, it can in general be done. Then we have marketing specific special rules. That is, there are rules which are related to specific areas of online marketing. I have chosen 4 topics which I think are interesting. First question, spam and email marketing. So can you send to another person an email saying, yeah, I want to make business with you, please send me your check data and your banking account data, and you'll get $1 million. Just send me your email because it's a gift from a person deceased. So this email marketing without permission is always a big problem in data protection. Therefore, I have discussed this matter last Friday in Georgia. How does Georgia cope with the direct marketing? And even there are, so far as I've understood, there are some problems in coping with spam. In Germany, we think of email marketing as a problem not only of data protection, but as a problem of unfair trade law. And we have specific rules on that in Section 7 of our UWG, we have written in that you can only send emails to somebody without permission. Or to say the other way out, you can only send an email to another person with marketing content with express consent, so it means opt-in. So you need a consent to send marketing email to another. The same applies for telephone. You are not allowed to use a telephone to give your opinion on your products to another person unless this person has priorly consented to that. There are very strict rules, so you need to have opt-in, and as a matter of fact, for internet cases, you need double opt-in, because if you want to send a newsletter to another person, this person goes to your homepage, he wants to get the newsletter, so you have to send him information. You have asked for our newsletter, that's very nice. Click here, and then you get a confirmation email afterwards saying, yes, you have wanted to get our newsletter, and this is a confirmation. That means double opt-in. And double opt-in is a general rule which you need to obey. Take a second problem, cookies. So you get cookies without knowing it. Cookies are small data, a small tool, which is stored on your computer by Google and the others, and they are using the cookie in order to get a lot of information from you. So perhaps you know, how is it called? There are tools which are providing with help to avoid cookies. But if you don't use these tools, you simply are asked for a lot of information without even knowing it, simply because this very strange file is stored on your computer without your knowledge. So, is it allowed to do that? Is it allowed to store a cookie file on your computer in order to get information from you without your consent? Of course not. As cookies are totally prohibited. That is the reason for a big decision of the ECJ. You need to have an express provision consent. Without the express consent, it's impossible. So you see that in Europe, because you get a certain cookie banner. You get information, I want to store this secret file, do you agree? And only if you agree and you say yes, you have to say yes, then it's allowed. Cookies are always a problem, and therefore Google is thinking of abolishing email cookies, but it's still in operation. Whenever you use Google, you give your first chance to store cookies on your computer. The only exception we have in Europe for cookies are session cookies. When you use a banking account, for instance, the bank needs to know that you are a customer. Then for this session purpose, you can say cookies are allowed without consent. But if you want to use it for for marketing in general, then you need an express consent. Next topic, pop-up. Have you ever seen pop-up? There's a very nice homepage to test pop-up. That is a website called YouPorn. So now you have a unique chance to test YouPorn for scientific purposes. It's a quite boring website with a lot of porn on it. Imagine yourself, you're sitting there and testing YouPorn for scientific purposes, and you see your colleague is coming on the floor and is approaching to your desk. So, oh, it's very embarrassing. I won't stop it. When you stop it, there's a pop-up, other website coming up saying, do you want to meet other wives in your neighborhood? They said, no, I want to put it away. Then you close this pop-up, and there's a second pop-up that told you there is really one website, one lady who wants to meet you just 200 meters from here. So this pop-up might be so embarrassing that the ECJ and even the Federal Supreme Court in Germany said it's forbidden because it's unfair trade. Fourth element, influencing. Of course, influencer, they were formerly called product ambassadors. They are trying to promoting specific products. For instance, using YouTube. You know that some people earn a lot of money by making that kind of advertisement where they are saying, this morning I used the perfume of Chanel and it was so great experience. I like it very much. And they got simply for this kind of advertisement hundreds of dollars. To inform you, yesterday I got my first 10 euros from YouTube because now I'm accepted by YouTube as influencer. I don't know whom I influence, but it works. It's 10 euro. So I will, this afternoon, I will invite my wife and we have a nice, very nice coffee. So there are a lot of influencers running around, but the problem with influencers, are they advertisement? Are they providing advertisement services? Because if they are providing advertisement, they have to say, we are working for a company like so-and-so. That's the nightmare of influencing. They have to open their archives and say, we are paid by Nike or Adidas. The question is, they always say, we are not paid. Nobody is paying us. We simply go and get the products and that's all. Of course, as a matter of secret, they get some money for it. So the courts in France and Germany, they try to establish indications in order to say, if you have, for instance, 2 million followers, you cannot say, I am an honest product ambassador. That is impossible. You know? So there are some indications we can say there are really commercial business. So to mention some case from Austria, which I like, apart from influencing, a very important question in Europe, can you say, I have one website where you can order anything. If you don't want to give us your consent that we store your data, you can simply use a guest access so that you don't need to give your personal information to the company. And that's, for instance, a case from Austria where a guest access has been provided to avoid problems of unfair trade. So I think that's all for now. I close the first part of slides. Everybody is satisfied. Now I go to the question, whatever that means, in the area of unfair trade, or in a question of artificial intelligence. We have already discussed the first part. I explained to you what is typical regulation. I want to skip that. Let me see. I am looking for. No. One moment. Let me just quickly watch my slides. Yeah, watch the slides. In the slides, you will find a lot of more information on cases and so on. But after that, no, it's not here. Yeah. This is the beginning. So I come to the specific problems of AI. So what does unfair trade law mean when it comes to AI? Are there specific problems regarding AI and unfair trade law? In general, AI systems can generate content that might be misleading or deceptive. And perhaps you've seen the famous photo of the Pope wearing a white skirt of an Italian company. They can produce, AI can create realistic images, videos, or text that you can use for promoting, and the consumer is often misled. AI might as well cause algorithmic bias. What is algorithmic bias? Perhaps you mentioned, you may remember this strange nerd which we had several weeks ago, Merlin Rombach. He was explaining how strange you can create AI for secretly misusing algorithms. So AI systems can unintentionally present in the training data discriminatory practices. For instance, Amazon one day created an AI system for the search of new employees. They started AI and they noticed that women who want to become an employee of Amazon had less chances to get a job because the system unintentionally had a lower ranking of women as for future employees. So that's a big danger because you don't see it. It's simply in the algorithm strange. AI may as well be a kind of trade secret misappropriation because you can use AI in order to get to know trade secret. We have spoken about trade secret protection in general. So you can simply ask AI, please tell me about the business structure of that and that company. That's very, very dangerous, one risk of AI. AI on the long run can even help to build up a kind of monopoly. So the power of OpenAI for AI, for instance, the company behind ChatGPT, is enormous. And you can build up a kind of dominant position that nobody is controlling. And the problem, of course, is the AI systems in general open in a black box manner. You don't know how they get the output which you have just seen. It's all in the system without a chance of you to know who has made what information in the system. This is, of course, you see the problem as well in the area of automated price fixing, because the danger of AI is that AI suggests a certain price of a product, says the normal price for buying, for instance, your laptop. What is the kind of laptop? You should be listening. Yeah. Ah, yeah. How expensive? Or cheap? How expensive was your laptop? Oh, very good. Oh, because you don't see a price difference in the prices, and AI allows you to check all the prices in the world. You can say, I want to say, no, one shop in Munich is cheaper to buy your iPad in Munich or perhaps in Hamburg. And again, you don't know how the system works. You simply get the information and you trust the information because they say, oh, ChatGPT does work, doesn't know everything. So the typical problems we know so far, we haven't got any decision in Europe for that. So no court up to now has decided on the misuse of information using ChatGPT or other things. But a possible chance for an offense might be the answer of ChatGPT, because it is including false or inaccurate advertising information, or it might be that some company is promoted in comparison to another without justification. And we have as well this famous Section 3A, UWG in Germany and as well in Austria, where every regulation is a part of the UWG, even the air regulation from Europe might be interpreted as a violation of unfair trade rules, which makes life very complicated. So that is all for now, for the second slides. And now we come into the third slides, which are very important for me as well. Let me see, database. You remember we had this session on database right. And these slides were taken out of the slides from database right because there's one element which is striking for us. Who are the owner of data? So take, for instance, the example of Volkswagen, because everybody in the world should drive a Volkswagen. Now I'm making advertisement for Volkswagen, the best car in the world. You see my Golf Plus outside. So if you're buying a Volkswagen, you're not only buying a Volkswagen, but you are buying 3 computers, because there are 3 computers in every Volkswagen. What are these computers doing? They are checking all your oil in the car. They are checking the speed data are stored, whatever. It was former necessary for maintenance in order to provide maintenance service. These data are not personal. They can only be traced back to a car. So the question is, who owns these data? You as a customer, Volkswagen, or the holder of the car? So the problem further on is we have a rule saying that you can be owner of the data if data are tangible goods. So it's called in Austria, France, even in England, they have a rule for it. So if you could say that data are tangible goods, we can say somebody is the owner. Are data tangible goods? No, because they are not tangible. So can we apply the database right? The database right only gives an exclusive right for somebody for the way in which data are structured and collected. It doesn't give a right in raw data as such. So no exclusive right resulting from the database right. Is it a problem of data protection? We will talk about data protection in December. These data are not combined with a person. They only can be traced back to a specific car, but not to a person. So that causes a major problem in Europe. We can argue with exclusive rights in data. So I try to find somebody writing a doctoral thesis here at the ITM. If anybody wants to write a doctoral thesis here at ITM about the question, who owns the data, that will be lovely, lovely. Everybody who is an expert in Europe has written an article about the question, is there a property concept in data? I've written 5 articles about it, so everybody knows. But now I'm coming into a follow-up problem. If you can find any justification in saying you get an exclusive right in data. How can we solve the problem issues with competition law? Because if somebody is the owner of data, he has a monopolistic power. He can say, I have an exclusive right in the data stored in the Volkswagen. I am the only one who is allowed to sell it. I'm the real number one. And that relates to my slides. So let me skip that. So this problem has been mentioned in the Data Act. The Data Act says, what is the Data Act, by the way? Is an act we will talk about in the summer term, is a regulation of the European Commission, an act arguing about a data holder, data owner, and so on. In Article 43, there's a provision saying that the database sui generis right is not applicable. We are not allowed to use the sui generis right mentioned insofar as the Data Act is concerned. That's one solution for solving the balance between the data owner and the persons who want to get free access to data. But this solution can only be applied where the Data Act is applicable. The Data Act is only applicable to certain Internet of Things good, so it doesn't solve the general problem. How do we combine a monopolistic structure with freedom of information? The main solution can be found in antitrust law. And now we are skipping to antitrust. Antitrust is a problem of Article 102 of the Amsterdam Treaty. This is a fundamental treaty we have in Europe on the Constitution of Europe. Article 102 of the Amsterdam Treaty says, if somebody has a dominant market position, he has to behave just and fair. So he's not allowed to misuse his power in being a market predominant company. This principle of forbidding an unjustified predominant market power leads to the essential facilities doctrine. What that is, I will explain later in this lecture. And we have 4 decisions on the question, can we apply the principle of Article 102 to the ownership in information?
Yeah.
Yeah. Somebody's talking. So there's a famous case, Magill, the famous case, Bronner, the famous case, IMS Health, and the famous case, Huawei. First, from 1995, Magill. What was the famous case from the ETJ about? Let me just explain you the case. In Great Britain and Ireland, we have BBC and ITV, big television companies. They have good TV. Have you ever seen BBC? I think it was people in Uzbekistan, of course, in Georgia. Have you seen BBC? Yeah, nothing for it, huh? But they don't have a TV journal. So like Gong or Herzu is not known in Great Britain. So a Canadian was coming to Europe and said, oh, there's a new product. It's not known. They don't have a Gong or Herzu, no television journal. I will produce a kind of Gong Herzu for UK and Ireland. So what does somebody wanting to produce a TV journal need? Of course, the information about TV programs. So he was going to the BBC and ITV and said, I want to get the information, what is happening in 2 weeks' time in TV. They said, no, you don't get it. He said, why? Yeah, because we have a copyright in that information. Do you remember the times when I explained to you the sweat on the eyebrow in UK copyright? So big companies were sweating like hell when they have to organize the TV program. They said, simply it's our copyright. We forbid you to produce a TV journal. Is that a case of Article 102 of the Amsterdam Treaty? Is it a misuse of a predominant market position? The court said, yes, it is one misuse, because the main reason being copyright is a monopoly, because if you have a kind of exclusive right in information, you have a monopoly, you are the only one to decide the case of using the data. Second consideration of the ETD, you are preventing, as BBC and ITV, a new market, because was no TV journal in the past, and they simply said no in order to prevent a new market. And that's a misuse of a dominant position and is totally prohibited. You see, that was a consideration of Magill. Then take Bronner. Bronner was a case from Austria, which came to the European Court of Justice. Perhaps you know the famous Bild-Zeitung. We have famous daily newspapers. Even in Austria, we have them as well. These big companies have a totally perfect system of addresses of people who are carrying their newspaper to the customers. Mr. Bronner wanted to produce a new journal. And he said, please give me the address of people who are carrying the journals to customers. They said, no, why should we open our address files to you? They are our messengers if we need. Why should we open it for a new company? He claimed Magill. He said, it's just Magill. And the court said, of course, there's a big difference between Magill and Bronner, because in the Magill case, there was a new market. In the Bronner case, somebody wanted to enter an old market of traditional newspapers. He has no idea of a new journal. He simply wants to disturb the others from their business. And that is not a violation of Article 102. So, the third case, IMS Health. Here we have a German court asking the ECJ, and it was a case, the big companies like BASF and others are creating a kind of business card for sending pharmaceutical products to pharmacies. IMS Health was a Canadian company who wanted to use that map of sending a pharmaceutical product to the pharmacies for their purposes. In general, that was a case like Bronner. So because IMS Health was a competitor in an existing competition situation. So normally the court would say, no, this is not a case for Article 102. But the court said, interesting, because BASF and the other big companies had the help of the officials from Germany, the federal officials in the health business. So there was a kind of de facto standard, they call it de facto standard, and they have that map. So everybody who wants to enter the German pharmacies market needs this map. So in this case of a de facto standard, you can say this is again a misuse of dominant position. So I'm coming to Huawei, the last case. Again, a court decision of the ECJ, which had to do with following the situation. Let me imagine BASF and the others saying, yes, we made a very nice card with the help of the German authorities. You can get access to that card. No, not a problem. But you need to pay. And you have to pay 3 trillion euros. So trillion means million. So it was extremely high. So can you go to court and sue and say this extraordinary price is not existing? It is invalid. It's a violation again of Article 102. And the ECJ in the Huawei case said, if you want to deal with other competitors about information, and they have a kind of exclusive right, you have to deal with other competitors in a way that front is realized. What does for friend mean? I explained here, fair, reasonable, and non-discriminatory. So that standard is very important even in the summer term of our course, because every person who claims to have exclusive rights in information is under a friend obligation to talk to other competitors. So you need to have fair, reasonable, non-discriminatory prices. In detail, of course, it's always complicated to know, is 2 million too much? Or is it reasonable? That's the metaphorical cause to decide that. So the person having an exclusive right must submit an offer. So the person being the data holder, the data owner, is under obligation to submit an offer. The user can reject this by submitting a counteroffer, and then you have to do a talk without delaying taxes, and the offers must be a friend, and that is, of course, to decide up to the courts. Courts have to decide the matter. If you want to see that how that works, we have made a wonderful webinar on YouTube and talked to Mr. Krochil, who is an expert in these friend negotiations. So I hope you're all lucky. Mr. Böhm looks very sad and stressed, but it's okay. So, to summarize the unfair trade relations as such, we have unfair trade law first by the European regulations, but unfortunately there's a big gap in regulations which leaves the national states to use their own strategies for deciding on unfair trade. We have different models how the national states are using that gap. Some say separate acts, some say a combination of civil law together with consumer protection. Great Britain has nothing. Then we have, in most countries in Europe, we have the prohibition of misleading practices and a general clause saying that the courts are free to decide what is unfair trade. We don't have too many cases on AI and unfair trade, but we have specific cases on internet in general. Internet and unfair trade, especially using cookies and spams, that's very clear what you don't allowed. Apart from that, we have unfair competition, as that leads to totally different question. That is a question of how can we balance the rights of a data holder versus the freedom of information for business purposes. That's what I want to explain you today. Next lecture I will do on next Tuesday, and then I will speak about e-contracting and consumer protection. I hope you all agree that is a good topic, and I wish you a very successful rest of the week. Thank you.
Thank you, sir. You too. Thank you.